When justice fails at home, the world must respond. So this powerful idea gave birth to what we are going to discuss for today. So I proudly present to you the Rome Statute of the International Criminal Court. So the Rome Statute was created in response to the global demand for a permanent legal body to address or put an end to the impunity in the world's most serious crimes. It acknowledged the millions of children, women, men who have suffered atrocities that deeply shocked the conscience of humanity. After the atrocities in Rwanda and the former Yugoslavia, the inefficiency of the temporary tribunals were recognized by the international community, wherein a standing international court was needed to prosecute individuals who are responsible for crimes such as genocide, war crimes, crimes against humanity, and the crime of aggression, regardless of rank or political position of an individual. So the creation of the International Criminal Court, or the ICC, under this statute is a determined effort to end impunity, to prevent future atrocities, and ensure that justice is upheld for the sake of present and future generations. So the statute affirms that the most serious crimes of concern to the international community must not go unpunished, and their prosecution must be ensured through enhanced international cooperation. So the description of the Rome Statute is that the Rome Statute is the founding treaty of the International Criminal Court that was adopted on July 17, 1988 and entered into force on July 1, 2002. The statute established the ICC's legal framework, structure, jurisdiction, and functions. The statute is a multilateral treaty wherein it is an agreement among many states, and it creates the first permanent treaty-based international criminal court that is capable of prosecuting individuals, even the head of state, regardless of their rank or position. They can be prosecuted for most serious violations of international humanitarian law. The ICC operates independently of the United Nations, but the UN Security Council may refer cases to it. The ICC is seated or located in The Hague, Netherlands. So, to further know what is the reason behind the creation of this statute, what was the reason that drives into the creation of this statute? So in order for you guys to know it, let me discuss the historical background. Okay, so the creation of International Criminal Court and the development of the Rome Statute reflect decades of evolution in international criminal justice. Its origin is traced to the growing realization that accountability for the world's most serious crimes must be enforced at the international level when national system fails. So the idea of international prosecution emerged after World War II, with the Nuremberg and Tokyo tribunals trying access leaders for war crimes against humanity. Also, the 1990s witnessed a resurgence of interest in international criminal accountability due to horrific atrocities such as the Rwandan genocide on 1994 and the ethnic cleansing in the former Yugoslavia. Although there are ad hoc tribunals that emerge, but their temporary nature and limited jurisdiction expose the need for a permanent court to ensure global accountability. So in July 1998, the United Nations calls the Diplomatic Conference of Plenipotentiaries in Rome, Italy, bringing together the representatives from 160 states, NGOs, and civil society. Their aim was to draft a treaty, which is the Rome Statute, that leads to the establishment of a permanent international criminal court. And the adoption of the Rome Statute marked a historic milestone because for the first time, a permanent independent court was established with the authority to prosecute individuals for the most serious crime under the international law. The statute entered into force on July 1, 2002, after the 60th ratification. So now let's discuss the purpose or principles of the treaty. The purpose or principles of the treaty are as follows. Number 1, to end impunity. wherein it ensures that those who are responsible for the most serious international crimes are held accountable. Number two, justice for victims, wherein it provides justice for the victims of mass atrocities. Number three, complementarity, wherein the ICC only acts when national legal systems are unwilling or unable to prosecute. Number four, deterrence, wherein it serves as a deterrent for future would-be perpetrators of the most serious crimes. Number five, no immunity, wherein no one, and not even a head of state, is immune from prosecution under the Rome Statute. And lastly, due process, wherein it guarantees a fair trial rights and protection for the accused under international standards. So the key dates in this Rome Statute is that it was adopted on July 17, 1998 and entered into force on July 1, 2002. And the Philippines signed on December 28, 2000 and it ratified August 30, 2011. And the notice of withdrawal was submitted on March 17, 2018, then it took effect on March 17, 2019.
Now, I will be discussing the important provisions of the Rome Statute of the International Criminal Court. Number one is the establishment of the court. The Rome Statute, adopted in 1998, created the ICC as a permanent international court. Its primary purpose is to prosecute individuals responsible for the most serious crimes of concern to the international community. Number two is the jurisdiction of the court. The ICC has authority over four main crimes. These are genocide, crimes against humanity, war crimes, and crime of aggression. Number three to the important provisions is the complementarity principle. The ICC operates on the principle of complementarity. This means it acts only when national courts are unwilling or unable to prosecute these crimes. It does not replace national judicial systems but complements them. Number four is the triggering ICC jurisdiction. The ICC can initiate proceedings in three ways. Number one, a state party refers a situation to the ICC. Number two, the United Nations Security Council refers a situation. And number three, the ICC prosecutor initiates an investigation with authorization from the pre-trial chamber. Number five for the important provisions is the right of the accused. Individuals accused before the ICC have rights to a fair trial. This includes the presumption of innocence, legal representation, and the opportunity to present evidence. Number six is the victim's participation. Victims can participate in proceedings and may receive reparations for harm suffered. This ensures that victims have a voice in the justice process. Number seven to the important provisions is the enforcement of sentences. Sentences imposed by the ICC served in countries that have agreed to enforce them under the supervision of the court. Number eight, amendments and review. The Rome Statute allows for amendments and periodic reviews to evolve international law circumstances.
How significant is said treaty to the Philippines? Cite significant legislations enacted in response to acceding to the treaty. The Rome Statute is important to the Philippines because it established the International Criminal Court, or the ICC, which has jurisdiction over the most serious crimes to concern to the international community, which are the crimes of genocide, crimes against humanity, war crimes, and the crime of aggression. The Philippines signed the Rome Statute on December 28, 2000, and ratified it on August 30, 2011. and by ratifying it, the Philippines recognized the jurisdiction of the ICC over international crimes committed within its territory or by its nationals, as long as its national courts are not able or not willing to prosecute such crimes. To complement its obligation under the Rome Statute, the Philippine government enacted Republic Act No. 9851 or the Philippine Act on Crimes Against Humanity in 2009, wherein the law aimed to domesticate the provisions of the Rome Statute by defining and penalizing international crimes under Philippine law. It also demonstrated the country's willingness and ability to prosecute these crimes within its own legal system, and supporting the principle of complementarity under the ICC's framework. However, in 2009, also all of us know that the administration of former President Duterte, the Philippines formally withdrew from the Rome Statute. The decision was said to be driven by concerns over national sovereignty, alleged violations of due process, and claims of bias by ICC prosecutors investigating the Duterte administration's war on drugs. Despite the withdrawal, the ICC maintains jurisdiction over crimes committed while the Philippines was still a state party from 2011 until the withdrawal became effective in 2019.
The treaty itself made a huge impact on overseeing crimes against humanity and encouraged states to, of course, respect the aspect of human rights. While on the other side, the treaty was criticized by non-member states, especially those that have withdrawn from the treaty, that it undermines their sovereignty, and also they perceive hypocrisy as its effectiveness is only focused on poorer states rather than the other states that are powerful.
So for the current news article about the treaty, number one will be the GMA News report that the ICC has jurisdiction over crimes committed while the Philippines was under Rome Statute, said by the spokesperson of the ICC. So this article reports on a clear clarification from the International Criminal Court or the ICC, specifically from its spokesperson Fadi El Abdallah, that the court retains jurisdiction over alleged crimes committed by the Philippines during the time it was a state party, the Rome Statute from 2011 when it ratified the treaty until 2019 when its withdrawal took effect. So, the ICC spokesperson emphasized that a country's withdrawal does not remove the court's authority to investigate crimes committed while the treaty was in force, which means that the ICC still holds the legal power to proceed with its investigation into alleged crimes against humanity during the war on drugs of former President Rodrigo Duterte. So this article shows the principle of non-retroactive withdrawal, which is a foundational element of the Rome Statute that ensures justice is not evaded simply by leaving or withdrawing from the treaty. Number two will be the Guardian's report on Rodrigo Duterte and ICC custody after the arrival in the Netherlands. So in this news article, former President Rodrigo Duterte was arrested in the Philippines and turned over to the ICC in The Hague. So this marks a historic moment as former President Duterte is the first former head of state from Asia that was taken to the ICC custody. The arrest rooted from a formal ICC investigation into alleged crimes against humanity that was linked to his administration's anti-drug campaign or the war on drugs, which is accused of widespread extrajudicial killings. So this event is highly significant as it shows the ICC's ability to act on its mandate, that even former state leaders, regardless of their rank or position, thereby the ICC still asserting its role in combating impunity. It also sparked a political and legal debate if whether or not the ICC has jurisdiction over the Philippines, considering that they already withdrew its membership, and debate over sovereignty, international cooperation, and justice. That will be all. Thank you.